We're going to have a really nice presentation this morning. Main focus is on contract changes and legal disputes. And our presenter is a good friend of ours, Matt Schoonover. He's a founding and managing member of Schoonover and Moriarty. Matt has worked with us on a number of different projects and workshops, and he's been just spectacular this past year working with me, having an interest in helping me get this information out to all of my clients here in Southeast and Central Washington and beyond. He's a strong supporter of the PTAC program. He's been involved in our bridging partnerships and our Alliance Northwest, our APTAC trainings. And we at PTAC just have so much respect for he and his services because when we have our annual trainings too, he is kind enough to be there and present his information and then follow up one-on-one with presentations like this. I'm so happy to have him here with me. Matt counsels clients really on all aspects of their work with federal government, from understanding the acquisition regulations, contract provisions, to ensuring compliance with regulations relating to small business and the socioeconomic program eligibility, as well as developing mentor-protege agreements, joint venture agreements, and subcontracts. His law firm, Schoonover and Moriarty, also represents contractors in bid protests, size and socioeconomic eligibility protests, and performance disputes. Above all, Matt enjoys helping small businesses succeed in the federal marketplace, which is exactly why he's here today. I want to welcome Matt and thank him so much for being here today. I'm going to have Matt run through his presentation, and Matt, I'll let you decide if you want to take any pauses for Q&A as you go or introductions. I'm going to let you run it from here.
Sure, that sounds good. And if if there are any questions throughout, I'm certainly happy to take them, and we should have some time at the end as well. I'm delighted to be here, and Jody, thank you so much for those kind words. We love working with our PTAC friends, and particularly those up in Washington State, really supporting their mission and making federal government contracts more accessible to small businesses. There are a lot of headwinds, as many of you know, for small businesses when they go to work with the federal government. We really support PTAC's mission in trying to kind of smooth those things out and make that process easier for small businesses. And I'm delighted to be here today to talk about really one of the issues that pops up once you have that contract. It's gonna happen that there is a change under your contract, and whether that change comes from change in scope or funding issues or what have you, the question for contractors is, what happens and how can you be prepared for those, and how can you address those changes with the government? So I'm delighted to talk about this today and to join you all in doing so. I am Matthew Schoonover. I'm the managing member, as Jody mentioned, of Schoonover and Moriarty, and we work with federal government contractors of all shapes and sizes on their work with the federal government. And importantly, although I am an attorney, please don't take today's presentation to be legal advice. Obviously, these topics have a legal aspect to them, a legal bent to them, but each situation is different. And we'll kind of talk about general tips and pointers today. Please, if you have specific questions or specific issues, make sure that you're talking to Jody and her team, or reach out to a government contracts attorney, be it me or a different attorney, to get the best possible advice for that situation as possible. So today we're going to be talking, as I mentioned, about contract changes and really what you can do as a federal government contractor to minimize the sting of a change and to minimize the chance of a dispute relating to that change. And we'll first talk about, what are changes? There are changes under the FAR, there are changes outside the FAR, and so we'll talk a little bit about those various changes and how those changes might lead to a dispute with the government. Hopefully it doesn't happen. A lot of times when there are changes to a contract, the contracting officer recognizes that and allows there to be either additional time to perform or additional costs associated with that performance, but not always. there's not always, seeing eye to eye that maybe something is actually a change or a compensable change under the contract. And in that case, we'll talk a little bit about the contract disputes process. Nobody wants to go through it. But I've found in my practice that it can sometimes be inevitable. And if it does happen, what are your options for handling that dispute? And I want to say at the outset, the dispute doesn't always mean, pound the table litigation against the federal government. Not at all. A lot of times when we get involved in these disputes, it's trying to negotiate a resolution to disputes before they really reach that stage. And so there are options to resolving or to handling those disputes that I think make sense. And then we'll talk about best practices. How can you prepare yourself as a contractor or even as a subcontractor for making sure that your business is best situated for contract changes and contract disputes. So let's first start by talking about contract changes. Changes, it sounds really simple, and in a lot of ways it is, but really a change is just a modification to some aspect of the contract. When you enter into a federal government contract, that's just like any other contract you might enter into, where the government has contracted with you to provide a specific good or service for a particular amount of money. And sometimes during the course of performance or during discussions between the parties, that contract might change based on what the parties originally thought they were entering into. This can be the specifications of performance or how you're actually going to meet those specifications. Maybe it's changing the time of access to the government's site in order to meet those changes. It could be a change to the government's obligations. Maybe there's a difference with the equipment or the government furnished information that they're going to provide, and that's going to impact your performance in some way. Maybe it's a change relating to how the government's actually going to pay you under the contract. It could affect the government's obligations under there. It could also impact schedule, when you will perform various aspects of the job, or when delivery or the deliverables have to be met. So really the modification to the contract can come under any of the contract's terms. They can be additive or deductive. And by this, I mean, maybe the government is asking you to do more work than what you originally had thought you would have to do under the contract. Or conversely, maybe the government is taking away some of the work. And that doesn't necessarily mean that they're taking away some of the work to punish you. But maybe some of the work that you were going to perform was required or followed on the work of another contractor, and that contractor hasn't met performance. Or the government has just realized, well, we don't need this particular scope of work performed now. We're going to solicit that work later on in the future. The government might try and reduce the scope of work under the contract. And these changes can be asserted by either the contractor or the government. I do want to make this point clear that a lot of times, and I'm fond of saying this, that when you're contracting with the federal government, it's good to be king. And by that, I mean the federal government has a lot of leeway in its contracts because the federal government is the federal government. It writes the rules, it has all the contracts. So there are a lot of advantages to being the government under the contract, but that doesn't mean that a contractor is powerless. There are abilities for the contractor to come back and say, listen, government, we think this is a change under the contract, and you have to fairly consider that. And the FAR does require them to do that. But importantly, whatever the change is, it has to be contemplated within the original scope of the contract. If you're adding work, or if the government is adding work to the contract in particular, in order to really be a true change, it has to generally fall within the original scope of work. If it doesn't, if it's something outside of the anticipated scope of work, then really the government should be competing that new work under a different contract vehicle. It doesn't always do that. Again, sometimes the government tries to shoehorn new work into an existing contract, but technically, if changes are outside of the scope, then that new work should be performed under a new contract vehicle. Now, how do you determine whether something is inside or outside the scope of the work? Well, that's going to depend really on the particular contract at issue. You're going to want to see, of course, what the existing scope is and the existing time of performance is, the existing anticipated costs. And if something, falls far outside of that or really does modify that, then you could say, well, this is outside of the original scope. Now, maybe if you're the contractor, you don't mind performing work that's outside of the original scope. Maybe you think, oh, okay, well, this is more work that I can perform for more money and I don't have to go through the competitive process. You might make a decision as a contractor to not necessarily object or mind if the government asks you to perform work outside of the original scope of the contract. That's kind of a strategic decision that you might need to make. But keep in mind that if the government is modifying the scope of an existing contract to include work that's outside of the scope and a competitor gets wind, they might consider a protest challenging the fact that that work was not competed. So, to kind of sum things up, when we talk about changes, these are revised contract terms of requirements. And yes, they may often arise during contract performance. And a lot of times they address things that are coming to light during that performance. Let's take a construction contract, for example, or maybe a waste remediation contract, perhaps is more apt for today's presentation, particularly if you're working over at the Hanford site. If there's a waste remediation contract and you are required to remediate, let's say, 100 acres of land over at the Hanford site. And during the course of performance, the government realizes, well, maybe we can't do the entirety of the 100 acres here. And instead it wants to focus on just a particular plot or a building on that acreage, then it might implement a change to reduce the scope of that contract. Or if your time to perform has changed for one reason or another, let's say that there's delays in performance and those are excused delays, then maybe the government would enter a change due to those delays. I will be very careful, or I think it's important for contractors to be very careful, though, to make sure that they're aware of scope creep. And we'll talk more and more about that. But as a contractor, you need to know going into it, what am I defined to do under this contract? And if the government tries to get you to do something beyond that, then a change order is appropriate there. Not only do you need to be paid for that work, but it needs to be wrapped up into your contract to make sure that you're getting credit for it and that those deliverables are met. If there's differing site conditions, maybe you go on the project and the government is represented, listen, there's no groundwater, there's a groundwater study that says there's no groundwater, and you go out there and you start digging and all of a sudden, it's an underground river. If there's differing site conditions that affect your work under the contract and what was represented and reasonably available to you, then you could be entitled to a change order. And I also mentioned excusable delays, one of which we've all been living through for the last 2 years. The pandemic is, in a lot of instances, an excusable delay. And in that case, if you're having issues with staffing, if you're having issues with meeting the deliverable requirements because of supply chain issues or quarantines, all of that type of stuff, there could be a reason for a change there. Same with acts of God, tornadoes, all of that type of stuff. There could be reasons for claiming a change under your contract. These changes oftentimes are allowed under the federal acquisition regulations. You know, there is a clause that is incorporated into just about every federal government contract that allows the government and the contractor flexibility in addressing these issues as performance pops up. And they're listed here on the screen. You know, pretty much FAR 52-243. And the most common one it's highlighted on the screen is -4. And this is kind of the basic changes clause. But that, you know, these provisions provide for the procedures necessary to address these circumstances. So if you're a contractor and you think that there might be a change under the contract, one of the first things that I would suggest doing is pull up your contract and see which changes clause is incorporated into your contract. It could be incorporated by full text or even just by reference, where they just note that this particular clause is in the contract, and then you would have to go to the FAR, to acquisition.gov, and pull up the latest version to see what applies here. And I've got the one for the 52-243-4 on the screen. But it says, in general, the contracting officer may at any time, by written order, make a change to the work or the scope of the contract, including in the specifications, the method or manner of the performance of work, government furnished property or services, and the schedule, directing an acceleration in the performance of the work. These are the things that we talked about earlier on. The government can also make, you know, through discussions under subsection B, make or give directions that might constitute a change under the contract. And in that case, if the contractor believes that through discussions or the requirements of the contracting officer, something within the contract has changed, then the contractor is obligated to provide the contracting officer with written notice saying what they believe the circumstances of that change are. And its justification for believing that that is a change. And importantly here, the FAR also says that unless the contractor follows these requirements, it generally is not entitled to an equitable adjustment under the contract. And subsection D here, D and E are very, very important because they lay out the contractor's obligations. And I realize it's kind of hard to follow on the screen here. It's just kind of, you know, a block of text. But in general, your contract is going to require notice requirements that you have to notify the contracting officer within a certain amount of days, both of the fact that you think that there is going to be a change and what you actually are requesting for that change to be. And so know that as a contractor, you have to act fast. You know, you see that you know, in some cases that notice can be as short as 20 days under the contract if you believe that there has been a change to the specifications or to the contract. So you really need to make sure that you're providing this information as quickly as you can to the contracting officer. Now, a lot of times people ask me, Matt, I don't know. I mean, sometimes I might not know what the costs are going to be of a change to the, you know, to the contract, and that's fine. I always tell folks you need to notify the contracting officer as early as possible, you know, within that time period that you think that there has been a change under the contract. And you can say something like, I'm not quite sure what this cost impact will be or what the time impact will be, but here is my estimate. And you can try and give them an estimate and say, you know, I'll provide final information as soon as I can. That type of stuff. I generally think that you want to put the contracting officer on notice as soon as possible and give them as much information as you can as early in the process as possible. That's going to make it easier to claim a request for equitable adjustment later. But a lot of times changes don't just happen. They don't just, kind of follow the regular FAR process. The FAR, as I mentioned, has policies and procedures that indicate, if a contracting officer believes, hey, I think there's been a change under this contract and I'm going to execute a change order. But a lot of times that's not how this kind of pops up. That maybe the contracting officer doesn't believe that, or isn't intentionally trying to change the contract. Well, in this case, we're kind of talking about the constructive change doctrine that affects government contractors. And these are really the informal changes made through an agency's conduct that affect your performance. And the most prominent example, and the most, I think, dangerous example of this is scope creep. When you're performing under a contract and you've got somebody on site who is telling you to do more and more and more of the job, and it's not necessarily in your contract, it can be hard for a contractor to kind of push back on that. But know that if your scope extends beyond what the contract originally requires, you're entitled to a change and you're entitled to payment. The problem with scope creep is a lot of times, I raise the example of contracting officers' representatives because a lot of times they're the person that is on site directing the actual day-to-day performance of the work. The contracting officer herself might be located miles and miles and miles away from the actual job site without a lot of day-to-day interaction. But the contracting officer is the person who is obligated, who binds the government when it comes to contract modifications or incurring additional costs. And so if you've got a COR that's on site directing you to do more and more work, I tell folks you need to make sure that you're updating the contracting officer about the change contemporaneously. Just send a quick email to the contracting officer. Hey, we spoke to the COR today. In addition to doing X, they've asked us to do Y. We're happy to do Y. We think the cost impact will be this or whatever. Please let us know if you disagree. And you've at least put the contracting officer on notice so that if they do disagree, they can say, no, don't perform this work. I'm not authorizing this work. You don't want to be in the position later on where you do work that somebody asks you to do, but you're not going to get paid for it. Issues relating to defective specifications or withheld government knowledge, if they provide you with a spec to do the job, they are tacitly warranting that that specification is accurate and that you'll be able to, complete the job to that specification. If they're defective in some way and you have to change your manner of performance, that really needs to be done through a contract modification as well. Or if there's differing interpretations as to the contract, maybe when you were bidding on the opportunity, you thought that the project looked different than what the government does. Well, to get everybody on the same page, you technically need a contract change order. Failure to cooperate with the contractor, that happens, unfortunately, a lot, where if the government is not providing what it says it's going to provide or is not really working with the contractor to make sure that the contractor can actually perform, you could be entitled to a constructive change as the contractor, maybe additional time, maybe additional money to kind of overcome the government's intransigence, for lack of a better term. Now, I mentioned earlier that the concept of authority to bind the government is very important. And that is especially true when it comes to these type of constructive changes. They have to be directed by somebody with authority to bind the government. It's either the contracting officer. They've got authority to bind. Their signature is the one that says, yes, the government's obligated to pay this money. or by somebody else, maybe the COR, if it's approved or later ratified. And that's why I say, if you're working with the COR or somebody else on site, make sure that you are emailing or corresponding with the contracting officer about this issue. You know, I've got something, you know, kind of that comes to mind here. Let's say that you're providing grounds maintenance services at a DoD facility, and the head of that facility is saying, you know, hey, you have to treat for this particular fungus or this parasite because it's affecting the quality of the turf. Let's say that that happens. Well, if that's not in your contract, then you need to get that approved by the CO. You know, you need to make sure that the CO is obligating the government to pay for that change in work. And this, it's kind of a silly example in some cases, because you might be saying, you know, it's providing turf services or what have you, but it shows just how quick these things can come up. I had it happen to a client where they had to act fast because this particular fungus was very fast spreading. And they needed, you know, approval. The facility director said, do it. And now they're facing an issue because the government is saying, well, that person wasn't really obligated or didn't have the authority to bind the government. So we're currently discussing that issue. But that's how fast these things can come up. And it, you know, it could be a few $100, it could be several $1,000s that these constructive changes matter. And so you want to make sure that you're documenting each one. Nobody wants to work for free. And a lot of times that's what these constructive changes do. So what to do after a change? First of all, as I mentioned, you're going to notify the contracting officer. Provide notice to the government within 30 days or whatever other time frame is set under your contract as soon as you identify that change. Try and give them an estimate of whatever cost or time impact you think there is going to be. And then track that. Track your costs separately from that change. Make sure that you're tracking employee time to do that change separately as well, so that you can later go to the government and say, here's what I'm entitled to. This was their work specifically on this particular item, and so I'm entitled to this amount of money. Importantly, continue performance. A change does not excuse contractual performance while the government is negotiating. Now, I do say that if the government is expanding the scope in some way or modifying the scope, you don't necessarily have to perform that modified scope until the government agrees to the change and to pay you. You have to continue performing, though, as the contract requires. You don't want to, be deficient in your performance or otherwise breach the contract because you're negotiating a change with the government. So from there, once you've identified a change, how do you work through them with the federal government? And here the point is to avoid disputes, if at all possible. And a lot of times the government wants to avoid disputes too, by the way. Not every change escalates to that level. Some do, but hopefully through discussions with the government, we're able to avoid that. Changes, they can be a very difficult part of working with the federal government, because a lot of times, the folks don't see eye to eye on whether something is a change. All the while, as a contractor, they're oftentimes leading to increased costs or delays and all of that type of stuff. And you want, as a contractor, to try and push as much of that off onto the government as possible. And naturally, they want to avoid that. So that tension can lead to some bad feelings between the government and the contractor, but they don't always have to. If a change doesn't impact the cost or schedule, or if the government recognizes that at the outset, these type of impacts, then it's not always going to lead to a dispute. And a lot of times the government will come to you as a contractor and say, give us your cost to do this so we can negotiate this amount. It doesn't mean that if you tell the government this is going to cost you $10,000, then the government is just going to turn around and give you a mod for $10,000. They're going to look at that cost proposal and probably go through it and say, no, we think that it's $7,200. And at that point, you're kind of negotiating for the additional performance and the costs associated with that, but at least you're negotiating and you're not in a dispute posture. And I think that's important because going forward, the more you can negotiate and discuss these issues with the government, the more likely you are to preserve the relationship with them going forward. That's really important because, I think the government understands, they know, any contracting officer knows that changes happen under the contract. Their job, though, is to make sure that they're being appropriate stewards for the taxpayers during those changes. It doesn't mean that the government is in the business of nickel and diming small businesses, although it might feel like that sometimes, and I know it certainly does. But the government, has to make sure that they're meeting kind of these two requirements, that they have to be fair to their contractors. They also have to be fair to taxpayers. And so preserving that relationship, going into it with that negotiated posture, I think is very important for both sides. And it minimizes the chance that the government would say, hey, this is a problem contractor, or this is somebody we don't want to work with going forward. It reduces those litigation costs as well. We'll talk about performance disputes that lead to litigation. As somebody who's been involved in those on behalf of several clients, I can say that it is very expensive. And so while you're going through that process of negotiating the impact with the government, certainly keep that in mind. Is it worth potentially going through this whole process for whatever the amount of money that you're currently disputing is or negotiating over is? Now, that said, no matter how many times the parties go into it in good faith, and a lot of times they do, it still might work out to a dispute where they just can't see eye to eye. They have, the government and the contractor both have different interests that relate to contract changes. The contractor obviously wants to earn a profit. They want to make sure that they're covering as much of their costs internally as they can, and hopefully turn a profit under the job. And they also want to make sure that they're performing what they believe the contract requires. The government, on the other hand, wants to maximize that taxpayer value for under the contracts. They want to make sure that they're meeting the objectives of their procurement, which could differ between what the contractor actually thinks the contract requires. And so sometimes they can take a broader view of what is needed. A lot of times agencies say, well, here's what the program office needs. Well, that might be what it needs, but that's not what you solicited, or that's not what you contracted. So there can be a tension there. And a lot of times the government may come back and argue, hey, this is contemplated within the original scope of the contract, or the contractor is otherwise responsible for these changes. The government is not on the hook for them either when it comes to time or money to the contractor. The government really wants to stay within its budget, both time and money. It wants the work performed within the time it said it's going to be performed, and it wants to stay within its overall budget for that work from a dollar standpoint. And so it might make some of these arguments as this happens. If that happens and you do reach the point of a dispute with the government, if you can't see eye to eye with the government on a contract change, how do you resolve those issues? And let me say, that just because there's, quote, a dispute with the government doesn't mean that it has to be adversarial or acrimonious, all of that type of stuff. It can be very, very professional. a lot of times folks just have different interpretations of what is required, and that has to be resolved. It is not the the contractor saying, well, contracting officer, you're an idiot, you don't know how to bid this work, all of that type of stuff. It is not the government saying, contractor, you're silly because you don't know how to read the contract and you're trying to nickel and dime us. It's just the inherent tension from their competing interests, and it can be amicably resolved. And whenever we represent clients, we try and go through really what is a 3-step process for getting them resolved. First, you can always negotiate with the government. Then, if that is not successful, you can escalate those negotiations to something more formal, either a request for equitable adjustment or a claim, a formal claim under the Contract Disputes Act, as the case may be. And then if that doesn't work, then you're going to more of an appeal posture, which gets somebody else involved, either the Board of Contract Appeals or the Court of Federal Claims, so that they can weigh in and say the outcome, on the dispute. I think it's appropriate to start with negotiation. It is the most flexible way to meet these requirements and to make sure that both the contractor and the government are having their needs met under the contract. And the FAR specifically allows, it contemplates that contracting officers will agree to negotiations with the contractor if disputes arise. FAR 33.214 is the alternative dispute resolution procedures. It allows a contractor to request it, but it does say that government participation is voluntary. That said, if the government refuses to participate in ADR, if a contractor says, hey, I think there's an issue under this contract and I want to sit down with you and discuss it, and the government says, no, we're not going to do that, the government has to tell them in writing why they're declining it, why they don't want to go through this process with them. But if they do agree, that process is very, very flexible. It essentially allows the parties whatever avenue they want to sit down and meet them. You could do just informal discussions. Let's everybody get in a conference room for a day. We can listen to your side. You can listen to our side. We'll be frustrated. We'll be hot. We'll be stuffy. And then by the end of the day, hopefully we will be motivated enough to just reach a common ground. You can go through mediation, where you get a third party involved to kind of informally help you solve the dispute. Again, it's still a lot of sitting in a conference room and being hot and stuffy and uncomfortable. And by the end of the day, hopefully you reach something, but getting that third party involved who can tell both sides, the other side has merit for this reason, and you have merit for this reason, and let's see if we can negotiate it. That is often successful too. Arbitration can be another issue that the parties go through. Maybe a binding arbitration, which is kind of like a mini trial between the parties, where it's more formal and there can be more witness testimony and all of that type of stuff. But the process itself is generally flexible, and it allows the parties whatever they want to do to try and reach an outcome to them. You can also, as I mentioned, if negotiations don't work, request an equitable adjustment under the contract. And this, an equitable adjustment is some type of modification to the contract that, if you're requesting as a contractor, is generally going to change the time you need to perform or the cost associated with performance. The contracting officer should make an equitable adjustment under the FAR whenever a change happens in the contract. It doesn't always happen, though. And so you can ask the contracting officer to do that. It's a formal request. It's generally in writing. And though there's no real form that it has to take, you are going to need to include some information. It can't just be a few sentences or a paragraph that says, we want this amount of money for this reason. You really have to discuss the factual circumstances that led to the change and why you think the government is on the hook for that, or the government should bear the burden of that. You know, I always recommend citing the specific contract provisions or the statement of work that you think is at issue and is impacted by the change. Provide as much documentation and support as you can. And if you're talking about changing maybe the scope of the contract, include suggested language in there that says, here's what we think the contract should be modified to include. Do as much of the contracting officer's work for them as you possibly can. Sometimes, depending on the amount of money that you request, you might have to certify an equitable adjustment, particularly if you're working for the Department of Defense. But you know, again, in general, is no real requirement or real form for these specific requests for equitable adjustment. Now, you do have to file them within 30 days of receiving the change order or notifying the government that a change has occurred, unless the government has extended that deadline to do so. And that's why I always say, you know, hey, email the government, email the contracting officer and say, I'm putting this together. The government might come back and say, submit it at the end of the contract. And a lot of times that's okay. But know that you generally cannot request an REA after final contract payment has been made. You want to make sure that you're getting those claims in before you do that. Now, the next step in the process, or the next kind of rung on the ladder of seriousness when it comes to disputes, is an actual formal claim. And the formal claim is defined under the Contract Disputes Act as a written demand by one of the parties for either the payment of money in a sum certain or adjustment or interpretation of relief for the contract terms or other relief arising under the contract. It is a formal written demand for some type of relief under the contract. If you're asking for money, the requirement is that it be a sum certain. You know, you can't just say, you know, I want money associated with this change. You have to say, I'm claiming $422,000.38 or something like that. You know, whatever the amount might be. But again, even though, you know, I think a claim looks very similar to an REA, or an REA looks very similar to a claim in a lot of instances. They're both going to be in writing, and they're both going to discuss in detail the factual and legal reasons why you think you're entitled to this change, or why the claim should be granted. Again, cite specific contract provisions, provide supporting documentation, all of the information that you need to establish, here is a change to the contract, and I'm requesting this relief, and here's why, government, it's on you and not on me. Now, if one of the main differences between a claim and an REA is a claim has to be certified, particularly if you are seeking money over $100,000. That certification is set forth right in the FAR and in the Contract Disputes Act. It's really simple. I certify that the claim is made in good faith, that the supporting data are accurate and complete to the best of my knowledge and belief, that the amount requested accurately reflects the contract adjustment for which the contractor believes the government is liable, and that I am authorized to certify this claim on behalf of the contractor. That has to be in there if it's a claim over $100,000. Unlike an REA, there isn't really a requirement for to submit it within 30 days. The statute of limitations on a claim is actually quite long. It's 6 years from the date the claim arises. But if you wait 6 years, I think you're doing it wrong. You know, I tend to think that a claim needs to be asserted as soon as possible. That 30-day guide is a really good one for claims too, because again, you should still be notifying the contracting officer whenever you think there's a change under your contract. So although you have time, you know, don't dilly-dally. It's always best to file these things once they happen, and so that they can be addressed throughout. Now, the government might wait to address them all, after contract has been performed or something like that. But in general, you don't want to wait in filing them. So although they're similar, they do have some key differences. Again, the timing is the biggest one. An REA has to be filed within 30 days of the change and before final payment. A claim under the Contract Disputes Act, again, has to be filed within 6 years, but please file it sooner. Certification, certification requirements are generally different. The claim does have specific language where for NREA, for the most part, it doesn't. The biggest difference between the two, however, are what happens if they're denied. In REA, nothing happens. That is, a request for equitable adjustment, the government isn't necessarily obligated to act on. In theory, the government can get a request for equitable adjustment, stuff it in the drawer, and never say word boo about it. But a claim is different. A claim is governed by the Contract Disputes Act. And in general, the contracting officer has to reach a written decision on the claim within a soft 60-day deadline. I say it's a soft deadline because the government's the government. They can always extend that deadline. But if the government denies a claim in whole or in part, then you can appeal that, again, either to the Board of Contract Appeals or to federal court under the Contract Disputes Act. And so I kind of say that these are a series of escalated measures where, first you can negotiate with the government. Then if those negotiations are unsuccessful, you can submit an REA. Then if that REA is unsuccessful, you can formalize it through a claim. Sometimes, though, you might say, well, why am I going to submit an REA? It's just going to go to the contracting officer who's going to issue the decision. And if they deny it, I'd rather be able to appeal it. That's totally fine. You don't have to file an REA first. You can just go straight to the claim process. It's just sometimes maybe if the government agrees that there's been a change and is willing to work with you on it, maybe the REA process might be more appropriate in that case. So, just kind of at a glance, negotiation, I think, is always the best approach for resolving these issues. It's flexible, it's fast, and it's surely less expensive than going through a claim process. But it's a negotiated resolution, and nothing compels the agency to actually participate in that. Now, you can go all the way to a claim and get something more concrete and determinative from the government. It's in writing, and appropriately, it triggers the Contract Disputes Act, meaning if the government denies it, you can appeal it. But of the three, this is the most involved, and it tends to be the most expensive. Because it triggers the Contract Disputes Act, you really need to make sure that claims are full and sufficient. They include all of the information in them so that the contracting officer can reach an appropriate determination. So what happens if you have a subcontractor under one of these contracts? Subcontractors aren't immune. By the way, I omitted kind of the discussion of appealing them under the Contract Disputes Act, a denied claim. Just really quick, that does look a lot like litigation against the government, where if you have a denied claim, either if you go to the Board of Contract Appeals or federal court, there's going to be pleadings involved. And by that, I mean complaints and answers. There's the opportunity for discovery. You discovering information, could be documents, could be depositions, requests for admissions from the government, and them doing the same to you. And then there could be dispositive briefing, motions for summary judgment that say, hey, here's why I win, or the government saying, here's why I win. And if it's not resolved there, then it can go all the way to a hearing. These can take years to be involved in and be quite expensive. And so they're not issues that contractors should take lightly, but at the same time, they are important tools for helping contractors preserve their rights and defend their rights under a contract. Now, if you're a subcontractor, how does this all affect you? Well, subcontractors aren't immune from changes under the government, under government contracts. And a lot of times they're really affected by them because maybe it's their work that the government is modifying. If you're a subcontractor, you promptly need to notify the prime of any changes or impacts to your schedule, to your performance, to your costs that arise as a result of any of these changes. And I think it behooves both the prime and the subcontractor to make sure that there are provisions in the subcontract that incorporate a notice provision in the event of any changes, and provisions for handling these type of claims or claims from the subcontractor to the federal government. There is no privity of contract between a subcontractor and the government. That means that the subcontractor doesn't have a contractual relationship with the government itself. And as a result, it cannot directly bring any claims against the government. So instead, maybe the prime contractor has to pass that claim through as if it's its own to the government, or sponsor that claim on behalf of the federal government. If I'm a subcontractor, I want to make sure that that provision or that requirement is in my subcontract, because then I have the ability, if I think there's been a change to my work, to go after the federal government. But note though, unless there's a provision in here, I don't think a prime is really required to pass that through. And so if it's not in the provision sometimes, or if it's not in the subcontract, then sometimes subcontractors are kind of left at the prime contractor's discretion in that regard. Now, there are liability issues, to be sure. These issues are governed, subcontracts are creatures of state law. And so I always say it's appropriate to discuss, whether you're a prime contractor or a subcontractor, your agreement with a local attorney so that you can understand what your rights and obligations under it are. If there are disputes, those are going to be resolved at the subcontract level, but maybe the prime contractor would be on the hook for those issues, and then the prime would have to go back to the government to incorporate them. You're also going to want to consider whether there's any waivers or release languages that's in here, and whether it applies to any claims that the subcontractor might have against the government. They're really important liability issues, I think, for subcontractors to keep in mind as they are working under federal contracts, because they are going to be impacted by these changes. And now finally, we have just a couple of minutes left. So I did want to note some of the best practices that I think have popped up over the course of my practice to make sure that you're protecting yourself against changes and disputes as they happen under federal government contracts. First of all, and I think this one is so simple, but is often overlooked. Make sure that you understand the scope of the contract before you bid on it. Ask questions of the contracting officer during the proposal process. Make sure that you know what the government expects under the contract, so that if you win the contract, you understand what they're going to expect from you out of performance. And if you don't think you can meet those requirements, take a real honest assessment about whether you can meet those requirements. And if you don't think you can meet them, consider alternatives. Maybe it's appropriate to team or to enter into a joint venture, or maybe, quite frankly, it's appropriate to pass on this opportunity for now and get it on the recompete in a few years. But know that work scope before you bid. I can't stress to you enough how many times performance disputes happen because there's a disagreement about what the work actually requires. And if you can smooth that out at the outset, you're saving yourself a lot of heartburn later on. Make sure you're communicating in writing with the contracting officer as soon as a potential change is identified. Reserve your rights for time and money. You want to make sure that you're communicating that with the contracting officer. You can CC the COR for sure, but make sure that the CO is aware of this stuff as it's happening, and do it contemporaneously. You need to create a paper trail, records of your efforts and of changes and of your costs associated with them. Keep them contemporaneously. These disputes might go on years in the future, or they might not arise until years in the future. So you want to make sure that you're having as much documentation about your performance as you can. They need to be detailed. If there's aspects that are affecting your ability to perform, keep daily logs of that. Take pictures if you have to, so that you can set the scene years later about what was happening and why you think it was a change under the contract. Document your mitigation efforts. A lot of times the government's going to say, well, did you mitigate your costs under this change? Meaning, did you try and offset them? Did you try and minimize them? Document those efforts. If you couldn't, if you were delayed for some reason and you could not reassign personnel elsewhere, document that. Or if you could reassign personnel elsewhere, document that. If it was going to cost you, money to cancel equipment contracts during delays and then to go back and get it, make sure you're documenting all of that stuff, so that when you go to present it to the government, they can make sure that your course of conduct was reasonable. And if you have alternatives to the scope of performance, make sure you're presenting them to the government. Say, hey, government, here's what you think. We don't think that's going to work under the contract for these reasons, but what if we do this instead? Make sure you're presenting reasonable alternatives to the government for its consideration as well. Track everything. Keep records of time, keep records of costs, keep records of equipment, facilities, all of that type of stuff. Computing overhead, all of those lost opportunities can be very, very tricky, but keep your records relating to them. Please keep, records. And then finally, I also say, watch for releases and waivers in contract documents. A lot of times the government will put in release or waiver language in a modification later on or something like that. And it can be very broad. It can say, I agree to release the government from any claims arising under the work. And if you think you have a claim, you need to either get that language out of there or carve out your particular claim that you're thinking about, because otherwise it can be very hard to unwind a release or waiver later on. And so make sure that you're reviewing those documents very, very carefully. And if you think that there's information in those documents or information in there that says, hey, you're releasing this, or maybe it's a $0 modification, be very wary about that. Now, we have just some time for a few questions here now at the end. My information's on the screen, so if anybody has any questions that we're not able to get to today, please feel free to reach out to us. We're always happy to answer any questions that folks might have. But I did want to note one of the more recent changes that we're kind of seeing government-wide happen, and that is the changes as they relate to the new COVID-19 safety protocol, including the COVID vax mandate for federal government contractors. We've been tracking the vaccination mandates and have been posting about it quite extensively on GovCon Brief. In fact, we have a new post today that mentions that the mandate deadline is now extended until January 4th, 2022. But a lot of times the government they're either implementing this new provision through a bilateral modification or through the changes clause, depending on the agency. And I think a lot of the issues remain the same, is you want to make sure that you're preserving any claim that you might have as a result of the vaccine mandate. I don't know what those claims might be at this point. Maybe you need time, maybe you need money if you have to get additional employees or get them vaccinated or what have you, or there's costs associated with your performance. But make sure that you're carving out anything from the release or waiver language about that, because we have seen that pop up. And that is happening. I think NASA was doing it under the changes clause. Other entities are doing it under bilateral modifications. I've got some concerns with that approach, but that's a topic for a different day. But I will say that it's important we're discussing changes today, because government contracts, carte blanche, are undergoing changes, particularly as it relates to the vaccine mandate. So if anybody has any questions, I'm certainly happy to answer them as best I'm able.
Thank you, Matt. We'll give people an opportunity. I don't see any questions in the chat. I'd mentioned if they had anything specific, nothing there. So let's just open it up for conversation. It's just a tremendous amount of information, Matt. And I'm sure that people are going to want to review this a few times probably because there's so much involved or potentially involved, but very thorough. So is someone out there like to unmute, introduce themselves, a little bit about your business and any particular questions or comments you might have for Matt right now? Feel free to do so. Or put a note in the chat and I'll call your name out. Might be a little shy today.
Judy?
Yeah, hi Matt. Mike.
Yeah, I messed my screen up. I don't know what I did here, but I got a question for Matthew.
Sure.
Actually, I got a couple of them. So if I understood you correctly, because out at Hanford, DOE used to, and I assume they still do, I've been retired from a while now, but they used to use management and operating contracts. So a lot of the opportunities for small businesses were the subcontracts with the prime contractors. So if I understand you correctly, a lot of those disputes would be resolved in state law cases then. Is that accurate?
Well, those contracts might be a little different because I think it's as the prime under an M&O contract, as I understand it, in a lot of ways, that prime contractor kind of steps into the shoes of the federal government. Kind of a weird way to say it, but in a lot of ways, they're kind of obligated in that way. So it could be that those disputes, depending on what they are, would be resolved, at that level, at the prime contract level. But it also, I would have to take a look at the actual subcontract itself to see. But it also could be that, yes, you would have to, essentially sue them under state law or something like that to get relief under those contracts as a normal kind of contractual relationship as that would normally happen. But if there's a different process that is outlined in the subcontract itself, for example, or in DOE's requirements, then that process would probably govern there. I'd have to take a look at the specifics.
Okay, so it's not that cut and dry. It's a case by case type basis.
Yeah.
And I have seen disputes that were directly with subcontractors to primes and the other way around. But so my second question is, I've done some work out there, had some contracts for the last 4 years for as needed professional services. When my last contract was novated to a new contractor and year 2 came up, there was a substantial amount of flow down clauses that came to me, which quite honestly, most of them worked only in favor of the prime contractor, which I get. But the one concern I had, because I was considering other options at the time, was how I could get out of the contract if I decided I was going to do something different, how to get out of it without spending money on an attorney like yourself. And I was kind of surprised when the contracting official wasn't sure what my options would be, and had to go back and discuss it. Well, in the end, I decided simply to opt out of year 2, rather than be locked into something that had a 5 years, and I just didn't like the way it was being set up. Is that fairly typical for a subcontractor? Because the concern I had was I was used a lot for 3 years, and then COVID hit, and it was like, every 6 months I'd get a call, and then, I get it. They can't tell you when they're going to need you on an as needed contract, right?
Sure. So,
but I was kind of surprised that there wasn't some. He goes, well, we can't put anything in there that would allow you to basically opt out because whatever reason.
Yeah, and that is a common. It's a common thought that as a subcontractor, you can say, or even as the prime contractor under a federal government contract, you can say, I'm just not going to perform my option. I'll just get out of it at the option period. That's not really how options work. When you're a prime contractor and you have an option contract with the government, you as the prime contractor have told the government, it's up to you to exercise this option, government. I'm giving you this right to exercise it if you want to for this amount of money, but that's up to the government. And so the contractor doesn't really have the ability to say, well, I'm not going to perform that option. It's something that has to come from the government. The same thing happens under a prime and subcontract if the subcontract has options. And so that's not really the way things happen. Now, depending on the scope of the arrangement and whether there's other subcontractors that can already be there, maybe the parties agree, okay, your performance is going to be done at this particular thing, at this particular phase. That's the beautiful thing about a contract is so long as both parties to the contract agree, they can be modified to say just about anything. Or one party can give up its rights under the contract and all of that type of stuff. And so that happens at some points. And it sounds like yours was probably just that situation where both parties realized, okay, we can get away with it under this contract and agree to be done with it. Now, maybe if you had been performing more work and more vital work under the contract, if you had gone back to the prime contractor and said, I want to be done at option year 2, maybe the prime contractor would have said, no, we need you on performance because otherwise our performance is going to suffer. And then at that point, they would have had more rights.
Well, my situation was probably a little different than most in that I was called out on an as-needed independent basis to conduct investigations for the company. And so if there was a major allegation that they felt they wanted an outside independent licensed investigator to handle, I would do that. But at the same time, I also had contracts with other companies. So I kind of figured I could, if they said, hey, we got an assignment, which was typical, can you be here next week and start on this? I figured I could say, no, I can't really do that right now because I got other clients I'm working for. So basically, I would just not accept the work. But then I thought, well, that may be a bad way to handle it. And two, I just wanted to avoid a situation where I could be looking at spending more money fighting something if that situation arose and just letting it go. So
Gotcha.
Yeah. Well, it sounds like I made at least a decent decision, the right decision for me, sounds like. So
yeah.
Great questions, Mike.
Yeah, absolutely.
Because it is kind of unique when you're in that kind of PRN or as needed basis. In the meantime, you've got business with other clientele that you're working with out there, and short notice is difficult to accommodate sometimes. So really good questions. I'm glad you brought that up.
Yeah.
Well, like I said, I've seen some of the folks that were at the one meeting we were at. I mean, I'm retired from the Department of Energy Inspector General's office, so I've seen how many times small businesses can get into a jam, right? Because they didn't get or understand something, which is why I tuned into Matthew's great presentation. So yeah, I didn't want to be the guy that should have known better and ended up losing money on a contract.
Yeah, those kind of things we wish we'd have known earlier, kind of thing.
Yeah.
Well, really appreciate you sharing that information, because there may be some others that have similar situations that come up. Thanks, Mike. And I'm glad you were able to join today with some last minute getting you set up. Let's open it up to anyone else. Megan, do you have any questions for Matt today or any comments you'd like to add?
Good morning, Jody. Hi, Matt. Sure, I'll jump in. You had mentioned, as we were talking about COVID, doing bilateral contract changes. I've seen unilateral contract changes. I'm curious about your thoughts on that. Kind of puts us even more in a pickle, I feel like.
Yeah. Unilateral, where the government's just coming back and saying this is now a part of your contract, that at some level I kind of feel better about that than a bilateral mod, so long as, again, there's no release or waiver of claims. I do not think and the government, I'm sure, is going to disagree with me. I don't think that the government can issue a unilateral mod with a release and waiver in there. You know, if they're going to give you a unilateral change under your contract, I think necessarily the the contractor has the right to go back and say, here's what I think my costs are associated with this. Now, if they have tried to have it both ways and say, we're gonna put this in your contract and you get nothing for it, I've got significant problems with that. But as far as them just coming back and saying, this is now a part of your contract, you know, I think I'm okay with that under the circumstances, because, you know, this is going to apply to contractors regardless. I mean, this is coming down from President Biden, and it's gone out through the FAR, it's, you know, gone out through the task force, all of that. So this is going to apply. And so for them to come out and put it in a unilateral mod to say this is now a requirement, I guess I understand. But the thing that I would want to make sure is, well, okay, what happens if we can't meet it for whatever reason? And then also what happens if it changes later on down the road? And these are this is more the issues relating to the actual COVID guidance that we're seeing that I kind of have problems with, unless more the instrument, the specific change of how they've done it here as a unilateral mod. But you know, I think in some ways for the government, it simplifies things, you know, just to say, here, this is a unilateral mod, it's now part of your contract. And perhaps it gives contractors, you know, that ability to say, I can't, you know, this is the government pushing this down on me, so I've got to comply with it. I've not seen them do it via a unilateral mod, except, well, I guess I would say, maybe through the changes clause 52243-4, as NASA did a few times. I think maybe that was a unilateral mod. And so it's interesting. Sorry, I kind of stammered through an answer that maybe didn't answer your question at all.
Oh, that's okay. I appreciate it. Thank you.
Yeah.
Thank you, Megan. Eric, you're here with us. Do you have anything you'd like to add, or any questions you have for Matt this morning?
Well, number one, Matt, I appreciate you coming out and you know, doing this for us. It's really great.
Absolutely.
Can't quite hear you, Eric. I don't know about Matt, but for me it sounds.
It's very faint.
Yeah. Can you get a little closer to your mic for us, Eric, so we can hear you a little better?
How's that? Is that any better? Is that a little better? No.
Yeah, it's a little tough.
Let me see if I can do this a little better.
Maybe you can use the chat. If you have something specific you'd like to bring up, you could type it into the chat. Maybe Matt can address it that way.
Eric, while you're getting your mic adjusted, I'll just throw it out there for Matt. So in our case, the unilateral modification was issued in accordance with DEER 970.502, or excuse me, 5204-2, which is laws, regulations, and DOE directives in our general provisions.
Okay. Yeah, and I know agencies have been updating. So I think the FAR basically came out and said, hey, you know, you guys can update the guidance or update contracts to include the guidance. And then each particular agency is kind of doing what's the I'm losing the word, deviations to their agency specific acquisition regulations. And that kind of sounds like maybe what the Department of Energy has done here.
Yeah.
To incorporate this. I know DOD's deviation, for example, the Department of Defense, they say that their preference is to go through a bilateral modification process to include that. And so I think the particular vehicle that agencies are using to actually put that requirement in the contract may differ. Now, at the end of the day, I don't know if the actual vehicle that they're using there matters so much as, again, if I'm the contractor, I want to make sure that I'm reserving my rights to file a claim later on if I need to. And if this does go away for whatever reason, I think it's important for contractors to be able to say, we want this to go away too. That's that's kind of one of my beefs when it comes to a bilateral modification where maybe you're agreeing to this change to your contract to incorporate the guidance. If it ever goes away for whatever reason, let's say one of the lawsuits, I think there were just 11 states that sued the federal government over the vaccine mandate. I think Florida was the first, and I think 10 other states have joined that lawsuit. But if for some reason it goes away or it's enjoined, if I'm a contractor, I want to be able to go to the government and say, well, then we need to get this out of the contract so I don't have to comply with it. Because otherwise, even if it goes away, maybe the government comes back and says, well, you agreed to it. So even though we can't require it, you agreed to it, you still have to meet it. So those are kind of some of the issues that pop up to me when I'm thinking about how the government is doing this. And that might not be so much of a consideration through a unilateral modification as it would be if somebody actually put their pen to paper and signed it. But again, I still think it's appropriate to think about from the contractor perspective, okay, how am I going to meet this now? And then what's going to happen down the road? You want to make sure that whatever that vehicle is, it's allowing you that ability to do that.
Sure. Thank you again.
Yep.
Hopefully, Eric, that gave you time to write your question in the in the chat.
Yeah, he wrote back and mentioned that the mic isn't really working properly, so I've offered up. Eric, you want to give it another shot, see if we can hear you now?
I can try it. Is that any better? Is that better?
That's I can hear you now. Yeah.
Okay. Again, Matt, thanks so much for coming out and doing this for us. It's really helpful, especially for us small businesses that are looking to try to do a little bit more within the COVID mandates, but also from what I kind of gather, it sounds to me that documentation is key in regards to any of those kind of discussions, whether they're just cursory discussions or actual contract discussions, so you can kind of lay that path of how you started to where you ended to make sure that everybody's on the same page. Right. That there isn't any questions or concerns with that. Is it appropriate to do that even if the client doesn't feel it's appropriate to do that at that time because it's not something that they think is either going to move forward or it's really not going to come to fruition? I'm always the guy that I would rather be safe than sorry. Yeah. And have it if I need it versus need it not have it. What's your take on that?
I tend to think that yes, it is appropriate to do. Now, one thing I will say is obviously if doing that will impact your ability to claim costs that you're otherwise entitled to, I'd think about it differently. But if what you're saying is, okay, I've got people who are doing this project for the government, I think that this is a change. Doing this particular task is a change and it's compensable to the government. They disagree. Nonetheless, what I would do is I'd probably still create, maybe like a job code in whatever billing system you're using or timekeeping software you're using so that people can track their time associated with working on that particular project. So then down the road, you can say, hey, government, I've got employees that spent, 62 hours doing this particular task under the project. And you're not having to go back and say, here's this person's time entries for the project overall. And I'm guessing that they spent, 32% of their time, all of that type of stuff. The more detailed you can get and the more specific you can get in your records contemporaneously to as it's happening, I think you're setting yourself up for success later on.
Perfect. Thank you very much. I appreciate that.
Yep. And by the way, let me say that I am by no means an expert when it comes to, contractor overhead, unabsorbed overhead, how to capture and track all of that type of stuff. There are consultants and folks out there that do that. And I know, certainly Jody and her team probably have recommendations. I have recommendations too. If anybody has any questions about stuff like that specifically, maybe on the more accounting aspect of things, again, I tend to say an ounce of prevention is worth a pound of cure, both in law and in medicine. And so it could be worth, depending on the scope of your business, maybe talking to one of these companies to say, how do I make sure that I'm putting stuff into place so that I'm best prepared for one of these issues going forward, even if I don't necessarily know that this is happening to me contemporaneously. That's always the hard part of when you say, I didn't know this was a change. How am I supposed to track something I didn't know was happening? That's always the very difficult part. And I don't have, a silver bullet solution for that. But it's appropriate to start thinking about, certainly at the time, of any contract award.
Good point. Yeah, I agree. Sometimes people contact us and have some specifics they're asking about. And while all of us have a pretty broad range of knowledge, there are areas of expertise I think are good to be honest with people and say, this is when I would suggest you refer out to an expert.
Yeah.
Because we want you to get the best, most up-to-date information we possibly can without trying to second guess anything. We certainly don't want to do that with any of our business partners.
Exactly.
So good questions. Thank you, Eric. I'm glad that worked. And Aaron Brooks, do you have any questions for Matt today or additional comments you'd like to share?
No, I don't, but thank you very much. Thank you very much. Thank you.
Thanks, Aaron.
All right. And Kelsey, do you have any specific questions for Matt this morning?
I don't, but thank you.
Absolutely. I'm glad you could join us this morning.
Yeah.
Well, unless anyone has any other specific questions, I think I'll just let Matt kind of wrap up with any final thoughts and guidance you'd like to share with our attendees today.
Yeah, absolutely. And I thank you all so much for the opportunity to join today. Again, my contact information is on the screen. So if you have any questions about really anything that pops up with federal government contracting, feel free to reach out. Even if I can't necessarily help, I'm always happy to help refer to somebody who might. And so, please don't be shy or be a stranger. You can connect with me on LinkedIn. That's also another good way to get in touch with me. But, certainly one of the things that I hope people took from today is that contract changes are just kind of a natural part of working with the federal government. And again, it doesn't mean that somebody's done something wrong under a contract, but it is appropriate to think about how can you protect yourself in the event of those changes. And most of the time, the government's going to be willing to work with you on that, particularly if you have a good relationship with the contracting officer and have kept them up to date about things that are happening under the contract. But of course, it's always appropriate to think about, well, what happens if this does need to go to the next step? And nobody wants that to happen, but certainly the more you can do to plan in advance, I think the better everything comes out to be. So I really do appreciate everybody's time today. And again, if there's any questions, please feel free to reach out. Otherwise, Jody, thank you so much for the opportunity. I wish we would see each other next week in DC, but one day in the future here soon enough.